May we just confirm that he's still in the oath? Just hold on, Advocate Meron. Let her first finish. Thank you.
Yeah, thank you, Chair. Chair, when we adjourned, a learned colleague, Hoffman, apologized for apparently referring to the cabinet ministers as minions, and he told the Commission that he was actually not referring to the cabinet ministers, but he was referring to staff. I think Mr. Hoffman has to apologize to staff. We have had directors general here, we've had generals of the army and other people giving evidence, and I think it's still impolite and improper to refer to them as minions. We don't need such language before this Commission.
Mr. Hoffman?
Thank you, Mr. Commissioner. I'm pleased to say that Mr. Mbeki accepted the apology in relation to the Cabinet and drew it to my attention that it is not appropriate to refer to the senior personnel who have graced this Commission with their presence as witnesses, and I have no hesitation in withdrawing the reference to them as minions. I apologize to each and every one of them, jointly and severally, singularly and collectively. It was unnecessary to do. It was done in the heat of the moment, and it was done in the sense that I was seeking to draw a distinction between those who have political responsibility for what has formed the subject matter of this Commission of Inquiry, and those who are civil servants doing their duty for the public of South Africa. So I've taken my medication. I'll be better behaved after lunch.
Thank you, Advocate Moran. I'm sure the issues now has been sorted out.
Thank you, Chair.
Thank you. Can we now continue the close examination, Mr. Hoffman?
Thank you, Mr. Commissioner. I want to return, unfortunately, to the question of the let's leave cost out of account, because it is dealt with in the JIT report with which Mr. Mbeki is familiar, and in particular I would refer him to what is said in paragraph 3.3 of a special SAAF Command Council meeting, in which they say in terms, and this is to be found in the JIT report, which is already before the Commission as I understand it, that paragraph 4.5.1.12, they quote from the minutes, and the minutes say, a separate recommendation is required where cost is not taken into account as per the request from the Minister of Defence, which is obviously a reference to Joe Modise. So it's very clear from these official documents that what I've been putting to the witness is in fact the truth. And then if you go further in paragraph 4.5.1.12 of the official JIT report, which is, as we all know, the document that was prepared to put all of the controversy around the arms deals to bed before I had any grey hair and while Mr. Mbeki was still a deputy president. In that paragraph, they say that there is a request. I'm talking at the second last line of the paragraph just before 4.5.1.13. There was a request by the AAC, which is the Arms Acquisition Committee, to consider a non-costed option. This led to paragraph 3.3 of the minutes as quoted above. That's the 3.3 that I've just read. Now, the bottom line of all of this research is that what I put to you is correct, that your cabinet colleague got the idea of a non-costed option, and in so doing, he tore up the part of our supreme law that requires that cost effectiveness be taken into account in the acquisition and procurement of goods and services in South Africa. And by so doing, he entered into a contract which has cost the people of South Africa 35 billion rand in aeroplanes that we use for World Cup soccer and fly pasts and very little else. And my question to you, Mr. Mbeki, is how could you let that happen as the man on whose desk the sign, "The buck stops here," rests?
Chairperson, I think that question should be disallowed for a number of reasons. Firstly, this matter has been canvassed extensively. Secondly, the question itself is confused. It conflates a number of things. We are not dealing here with what the AAC, that's the Arms Acquisition Committee, did. We are dealing here with what the IMC did and what the Cabinet did. This question has absolutely no bearing to what the IMC did and what the Cabinet did. And to make this horrific jump from what Mr. Joe Modise said, or might have not said, at an Arms Acquisition Committee meeting to what Cabinet decided, it's a non sequitur, it doesn't follow, and we are just wasting time.
Mr. Hoffman, my other difficulty is that, I've gone through quite a lot of those documents from DOD and from AMSCO. I haven't seen any Armaments Acquisition Council. I'm not a committee, Armaments Acquisition Committee is referred to it. I haven't seen it.
Well, it's in the acronym AAC is in the JIT report, and I am very kindly informed by the attorney acting for the Department of Defense that is just another acronym for the committee on which the witness served. And as far as the objection is concerned...
Just hold on, Mr. Hoffman. I'm aware of the Armaments Acquisition Council. This is what I've read from the documents I received. I haven't seen anything called the Armaments Acquisition Committee.
So maybe it's council, not committee. I'm sorry if I got the nomenclature wrong.
Okay.
They're calling it AAC.
So can you respond to what Advocate Marana said?
Yes. With all due respect to Mr. Marani, who enjoys a good relationship with me, we worked together in the Constitutional Court on the antecedent litigation that ended in a decision that gave birth to this commission. He is mistaken in making the objection, and I suspect that all he's doing is giving the witness a bit more time to consider the question that has been put. And the reason why I say that is because he has overlooked the very fundamental provisions of Section 2 of the Constitution, which I don't need to remind the Commission, says that any conduct that is inconsistent with the Constitution is invalid. So it doesn't really matter if the discussion is with the lowest of the low-level Defense Department people. The decision that is made is not made by them. The decision that is made by the cabinet. It is made politically. The civil service cannot possibly make a decision to spend 35 billion rand of taxpayers' money.
Thank you, Mr. Hoffman. We have heard that story before. Are you is the former president in a position to answer the question?
Yes, Chairperson.
Thank you. You can go ahead.
And to say, Chairperson, I've answered this question. I have said the Inter Ministerial Committee and the Cabinet didn't consider, at no point did they consider any option what might have happened at some departmental meeting or whatever else, I don't know. But I'm saying the effective decisions, the effective recommendation came from the IMC. And the only decision came from the cabinet. At other stages in this process, I don't know, but the decisions, the recommendations of the Inter Ministerial Committee all of them included the element of cost. As did what was even more important than any opinion of the Inter Ministerial Committee, what was important was the decisions of the cabinet. And precisely because it was serious about the matter of cost, the cabinet even instructed that we must work on this matter of affordability. So I'm saying, Chairperson, Chairperson, if you will allow me just to, 1 more minute. You know, the Advocate Hoffman is really quite insistent on making very offensive remarks. For instance, he says that Advocate Morane, he thought that Advocate Morane intervened the way he did in order to give me to think about the kind of answer that I would make, to give me time to cook up some story. That's what he's saying. There are other things, his statements he's made, like kingmakers like Joe Mundise. I know, I'm told, a Chairperson, that the proceedings here are being televised alive. I do hope that we're not making all the statements and all sorts of allegations about the usage of equipment because of that. I'm hoping. I'm not saying it's not, that's why. But I think that we need to show a little bit of respect for one another. Thanks.
Thank you. Advocate Morane, you know, I am a bit worried about the statements that Mr. Hoffman made, saying that this is what the minutes of the AAC indicates. My recollection seems to be slightly different because we do have copies of those minutes. I'm not sure if maybe Advocate Kane can be of some assistance because I recall that you went into details with witnesses when you dealt with those minutes.
Thank you, Learned. I have actually made a copy of the minute available to my learned friends who are acting for the former president, as it was part of the bundle when Mr. Steyn is evidence. And what is significant about the wording to which the JIT is referring is they refer to the 2 options, but the second, in relation to which cost was not to be the deciding factor, was what they also required, not necessarily that it was not to be taken into account. And my submission is that is a fundamental difference. Thank you.
Thanks a lot. This is how I recall it. The minute says that cost should not be a deciding factor. There was nowhere where it was said that cost should not be taken into account.
That is in accordance with the wording of the minute.
Thank you. I was a bit worried about that statement because I was hearing for the first time that at any of those meetings, it was said that costs should not be taken into account. As Advocate Kane said, it was said that cost should not be a determining factor. Are you...
I'm unfortunate. Sorry to interrupt. I hope I wasn't interrupting you, Mr. Commissioner. May I proceed? What I was doing when we got back on was reading direct quotes from minutes. Neither me nor my client have had anything to do with. And the direct quote, and this is obviously public servants covering themselves against getting into trouble for breaching the Constitution. The direct quote, and I read it again slowly, is paragraph 3.3.
Just hold on. A direct quote from what?
Direct quote from the SAF Command Council meeting held on the 29th of June 1998. Now that is referred to nicely and easily to find on 4.5.1.12.
Yeah, just hold on. We want to get to the actual minutes.
Yeah. Is quoted in quotes in the...
I mean the date of the minutes. Is the minutes of which meeting?
Yes, of the 28th of, as I'm reading this, of the 29th of June 1998. And it says... Right.
So is the minutes of the meeting of the 9th of June?
29th of June 1998, 29 June 1998.
Of which body? Of the AAC?
A special SAAF Command Council. So these are the people who are in charge of the SAAF, not as politicians, but as public administrators, public servants. And what they say...
Just hold on. Of this minutes.
It's in the JIT report.
Just hold on, Mr. Polofman. We want the original minutes. This is what I'm asking about.
Thank you, Commissioner. To my knowledge, the record does not have the minute of 29 June 1998 from the Special AAF Command Council. The words which are strikingly similar to the ones that are purportedly being quoted are words that appear in a minute of the Special AASB minute of 8 July 1998. And there the wording, if I may read it for the record, is the decision by the AAC during 30 April 98 briefing on the short list of offers required the project team taking cost into account and a solution where cost was not taken as a deciding factor.
Thank you.
The preceding minute, which led to the passing of that minute, which we suggest is unconstitutional, is a minute in which the public servants themselves say, a separate recommendation is required where cost is not taken into account as per the request from the Minister of... That's the way they approach. They're saying, if you politicians want to tear up the Constitution, do it on your own risk. Don't ask us as the people who have to process the decision-making to do it. And then my learned friend quotes from a later meeting in which this is all neatly finessed. And the bottom line is that the hawks are bought instead of the air.
Just hold the question of minutes. Apparently, the special ASB meetings minutes that we have of the 8th of July 1998, they are not correct. No. Or are you saying that the minutes that we are referring to...
I'm not
just hold on. The minutes that we are referring to is the minutes of the special AAF meeting, which minutes we don't seem to be having.
What I'm doing is quoting from the JIT report, which itself quotes minutes. And the minutes that I refer to are in June, the 29th of June. And in those minutes they are saying, in effect, you politicians want to do this on a non-costed or visionary approach, then you do it at your own risk. Pierre Steyn resigned because he wasn't prepared to do all this. So, it's not as though I'm breaking into new ground or revealing something that nobody's ever heard of before. In the ranks of the complainant people
and
that you still
just in order to make progress, has the question been answered, or do you still want to put the question again?
No, I haven't got an answer as to why cost effectiveness, which is a constitutional requirement, pain of which the deal is invalidated, has been ignored in the acquisition of the Hawks and Gripen jets. That's my question, and I haven't got an answer because the poor witness hasn't been given a chance to answer it.
Yeah, I see you've got Mr. Mbeki's interest at heart. You want him to be given an opportunity of answering. Former President, you heard the question. Are you in a position to respond?
Chairperson, he will have to help me. He says that there was something that was ignored. Ignored by whom? Because I've been insisting. Ministerial Committee and Cabinet did not ignore anything.
Sorry, I'm not suggesting that anything has been ignored. What I'm suggesting, and in fact what happened, is that the Hawks and Gripens were bought when the Defence Force said these are not appropriate, too expensive, not really what we want. But they were bought for a political reason or a reason that was decided in Cabinet, and I'm not going to point any fingers at you or anybody else about that in these proceedings at this stage, because what we are looking at in this stage of the proceedings is the constitutionality, the regularity, the question of misfeasance in the deal. And what I'm saying is that what happened in this deal is that we ended up with Hawks and Gripens that cost a lot more money and that weren't even wanted by the line Air Force people. That is what the JIT report shows, it's what the minutes show, and it's why Pierre Steyn said, I want no part of this, I'm out of here, I'm resigning. And it's because the Constitution
Just hold on, Mr. You've made such long statement. I'm not even sure which one the witness is going to answer because you've made so many allegations in the process. Can you try and break them down to small pieces so that the witness can understand the question?
Only with pleasure, Mr. Commissioner, because this is important. It's in fact critical to your work. And my concern is that what has happened, because of the visionary approach of Joe de Medici, which is, it's not a new thing, it's all over the papers everywhere. It's not something that we dreamt up this morning. Because of this visionary approach that did not take cost into account.
Mr. Hoffman, I understand it. Can you just break down the question so that the witness can understand?
The question for the witness, thank you, Mr. Commissioner. The question for the witness is, how could the South African Cabinet, committed to the constitutional order in which politicians are constrained by the rule of law and the supremacy of the Constitution, not go for the cost-effective option and instead buy more expensive aeroplanes? And the second question is, why? Let's stop with that one.
Yeah, just stop there.
Mr. Chairman, I object to this question because it's misleading. See, my learned colleague says that the Air Force itself did not want these. They were foisted upon by the politicians. That is a factually incorrect statement. If one has regard to the evidence...
Just hold on, Mr. Hoffman. I gave you a chance to make a statement. Let Advocate Morana finish, then I'll come back to you.
Mr. Chairman, if one has regard, for instance, to the evidence of Brigadier General Bain, he says a lot of things, but his conclusion at paragraph 57 of his submission is as follows. The SAAF today has an excellent, well-balanced and well-equipped fighter system capability within the ideal three-tier system, wherein the gap is higher between the first and second tier and relatively small between the second and third tier. The Hawk has also proven to have a cost-effective collateral operational capability, especially when packaged with the Gripen. The training success rate has been very high for air crew from various backgrounds and both genders. The Gripen has exceeded the SAAF's and SANDF's expectations, especially in the domain of modern fourth-generation integrated systems, deployability, logistic support, and reach. The Hawk and Gripen aircraft have also solved many of the past problems experienced by operations, mainly thrust, cooling, and communications. Clearly, the Hawk and Gripen systems have been well utilized since delivery in line with the current security environment. Should the security environment change to one of conflict, then the utilization of the systems will change as and when required to defend and protect the Republic in the line with the constitutional mandate. That is General Bain from the Air Force, and he gave evidence before this commission. So anything to the contrary of what he said is misleading.
On the contrary, what the General says now, ex post facto, is entirely irrelevant to what this commission has to determine. This commission has to determine what was happening at the time. And at the time, what was happening was that the South African Air Force was saying, give us the cheaper Aeromacchi option because it suits our conditions better. Please don't burden us with these expensive and unnecessary Hawks. And that is well documented in the documentation in the JIT report and elsewhere. And it is a valid basis for me to put it to the witness that that isn't what the Defence Force wanted at the time, and that these ex post facto statements that are made now in order to cover up the wrongdoing, the misfeasance that went into spending more money than we should have.
Just hold on. Are you saying that the Army, our SANDF, they came here in order to cover up the evidence that they gave? It was to cover up for misconduct of others.
The kind of evidence that has just been quoted by Mr. Marani is a sugar-coated effort that doesn't even begin facts about the Hawks. It doesn't mention that half of the Hawks are still stuck in their boxes and never been
just
opened.
Hold on. Advocate, you are acting for DOD.
I'm not acting for DOD. Sorry, are you speaking to my colleague?
Unless if you've changed it, now you're Advocate Kane too, then I'll be talking to you. Advocate Kane, this statement has been made. Your clients are Army, the Air Force, they were not telling us the truth. Will that be or will that statement be correct to be made by Mr. Paul Hoffman sitting next to you now?
Opportunity. I was hoping to be given one at this point. There are a number of levels that I need to deal with this on. The factual propositions being put to the present witness, the former president, and concur with my learned friend, Advocate Morani, that the evidence, the propositions being put, the evidence was overwhelmingly that the various items of equipment were assessed and that those that satisfied the technical requirements of the Air Force were put forward for further decision making, but that the Air Force itself did not express a preference within that choice of 4 aircraft that remain for selection.
I'm sorry, there is a cell phone ringing this side. Thank you.
With the result that my recollection of General Bain's evidence was that the Hawk had not won the selection criteria because of cost, but it was nevertheless an outstanding piece of equipment that met all the technical requirements, and if the politicians saw fit, the Air Force was delighted. And so that was the thrust of his evidence. If a different proposition wishes to be put by my learned friend, it should be put on a different basis then, not that it emanates from the evidence of a person like General Bain, whose evidence was quite the contrary, but that perhaps he has another basis for putting a different proposition. The second level of objectionability to what is now taking place is that these witnesses have come and given their evidence, and they were not challenged. Where the contrary submissions are coming from, because certainly Mr. Hoffman's client is no expert in relation to these matters. He doesn't put up any sort of qualification to second guess the evidence before you. To the extent that it's been drawn from other documents that are not now being made available or are being quoted from, such as the JIT report, then you know where the source is, but then it must just be put on the basis that it's a quotation from the JIT report, not that it emanates from the personal knowledge of a person who actually knows the facts. Thank you.
Thank you.
Thank you, Mr. Commissioner. Can I try and short? It's probably a matter for argument, and it's probably a matter for the commissioners to ponder the relevant parts of the JIT, which was a genuine effort by lots of serious senior civil servants to get to the bottom of the arms deal.
Maybe let me put it this way. I agree with you. It's a matter for argument.
Good.
Let's argue it at the end.
Let me just put one factual, because I've been accused of putting things that shouldn't be put. Let me just put one factual aspect to you, which is 2 lines, so that I can defend myself against the slings and arrows of outrageous fortune. That is to take you to paragraph 4.1.15 of, you call it JIT, do you? The JIT, the report. Paragraph 1.4.15 reads as follows. It's a very short paragraph. In July 1997, the President was advised by the Department of Defense and the South African National Defence Force of the reasons why the British proposal, and that's a reference to the Hawks and Gripens, was not acceptable. So that, I suggest, on the basis of what was happening at the time, is a fair reason to ask the witness, who's had a very long rest, what was going on when this decision was made.
Just for my own understanding, which British proposal are you referring to?
That is what was on the table in relation to the Saab BAE consortium that was offering Hawks and Gripens in competition with the Aeromacchi Italian aeroplanes and the French and the Germans. So there were 4 offers at one stage. Eventually it boiled down to a choice between the Hawks and the Aeromacchi, and what happened was we spent a lot more money on the Hawks than we would have if we had gone for the Aeromacchi. That is what the Commission will find as a matter of night following day. We're not making this up. We don't have sufficient imagination to make it up. That's what it's about, Mr. Commissioner. And I don't know whether having a huge debate. It's a very important point, obviously, but it's
okay.
having a huge
I understand.
debate between council about it now is not on.
I understand. Advocate Kane, as I understand the situation, for the Hawk and the shortlist came as a result of an evaluation by experts, and I think that technical team consisted of about 12, 13, 14 experts. And their findings was that all those aircraft that they recommended for RFO stage, they meet at least the minimum technical requirements of the Air Force. From there, the same team evaluated the RFO stage. They made a recommendation, and from there the other teams came in, the financing team, the IP team, and ultimately, that's how the preferred bidder was ultimately chosen. Will I be correct to say that is the position? And if that is so, then the proposition by Mr. Hoffman doesn't seem to be a fair proposition.
Commissioner, that is certainly correct. Where the perhaps misunderstanding arises is that it was the current Secretary of Defense at the time, Mr. Steyn, who strongly preferred the Aeromacchi above the Hawk and argued strenuously for the choice of the Aeromacchi in the various committees in which he participated. And that was fully canvassed with him. But from the Air Force's perspective, they had not taken a line of indicating preference. In fact, they abstained from it.
Thank you. In fact, I think one of the generals said that, as far as the Air Force was concerned, any one of the two will be acceptable because at least they meet the minimum technical requirements of the Air Force.
Yes, that was the evidence, Commissioner.
Thank you.
Mr. Commissioner, I want to close on this point because we're not making progress and we need to make progress. I can take it no further than saying, please look closely at Chapter 4 of the JIT report because you will find stuff there will raise question marks, if not hackles, or the warning signals above your heads when you read them. So
then what you can also do during argument, you can still raise that question.
Correct. Absolutely.
Good.
And there will be evidence from the authors and objectors that will enlighten the. So let's move on from the vision made peace about minions and trying to be that we are most of the time in the interchange with the witness. I want to take you now of way in which Thompson CSF became involved, frigate part of the contract. Sorry, I beg your pardon. And what I'm looking at here is according to the official record, Thompson CFS purchased shares in Alltech Defence Systems on the 14th of April. And they African Defence Systems, or ADS, and that that won the tender to supply the information management systems to be used in the Corvette combat suites. Are you au fait with any of what went on in that regard? Or is this stuff that was done by other people?
No, Chairperson, the matter about Thompson and its involvement in terms of the Corvettes is not a matter that was part of on the agenda of the Ministerial Committee, because this was a subcontract. We were dealing with the principal contractors. And the principal contractor was a German frigate consortium, which then took its own decisions about to whom it subcontracts, whatever. So that's a matter that would have been dealt with in that way.
On to June 1998, when the Department of Trade and Industry, which was then led by Minister Irwin, I believe, received a report that the BAE offset proposals were during this event that was going on. And going back to the JIT, Mr. Commissioner, the JIT notes that their offset
so your only source is JIT. You haven't gone into the documents themselves.
No, we've gone.
I'm
Mr.
just asking
I'm
out of interest.
I'm a new boy in this.
Oh, okay.
My client has been at it since 19. 5 other books have been written by other people. There's litigation in the Constitutional Court. There's the case that he had in the Cape High Court. And I've read all of that paper and am, for my sins, responsible for putting together the Constitutional Court application that has you this afternoon. So I apologize for that. But the point is that the information from well-informed people, including a former ANC
let's not go there, because we start mentioning other people's names.
What I know, and I'm telling you where I'm getting it from. Okay.
Now, the only point I was trying to make was that you seem to be relying only on JIT.
No, JIT is a good source, official source, and it's a source that a cabinet member, a cabinet leader, a former president, ought to be familiar with and be able to explain to us. That's why I'm doing that.
I understand that. You can go ahead.
So, you stole a lovely punchline, but I won't hold it against you. The JIT report in relation to these BAE offsets is that the offset proposals are a load of hot air. I don't know if you remember that at all, Mr. Mbeki, or whether you are prepared to comment on it. But I'm putting it to you as part of the narrative of how we managed to get to where we are with more expensive aeroplanes than we should ever have bought.
Chairperson, my colleague Alec came to the Commission to discuss exactly these matters. I would imagine that that's the person who should have answered these questions. But as for me, indeed, as I've indicated, would be questions that would have to be dealt with there in that interaction with Minister Irwin and of course the current ministers at the Department of Trade and Industry, because that kind of discussion that would have taken place there. He says there was a communication that got to TTI, Department of Trade and Industry, which said whatever. So it went to TTI. It didn't come to us in the Ministerial Committee. So it would have been dealt with there. Then something later came to us.
came to you last, and or eventually came to you. And what I'm asking you is, do you remember that scalding criticism of the BAE offsets? That's really the question. The rest was just leading you in.
No, I can't remember. I haven't read that report for a long time. I honestly wouldn't be able to say.
You didn't. You weren't advised to read the JIT report or really anything else in order to prepare for this.
No, I wasn't. And I wouldn't understand why I would have to.
Or perhaps to better equip you to answer the questions that you're being asked now.
Mr. Hoffman, can we continue with the cross-examination? Whatever advice that Mr. Mbeki got from his legal advisors, I'm sure it's not relevant. What is relevant is the answers that he gives to your questions. May we get to the next question?
Right, let's get to the next question, which takes us to July of 1998, and an attempt in July of 1998 on the part of General Pierre Steyn, who was then the Secretary of Defense, to stop the cabinet being presented with an evaluation that excludes cost criteria in choosing the lift option, in which he was just overruled by Joe Modise. So that at which you were present, you have no recollection, seem to be saying.
No. What? Yes, no, I was not. I was not at any such meeting. Let me just say this, Chairperson, as a matter of as chair of the commission, I never attended any departmental meetings, whether defense or trade industry or whatever. So in case this matter arises again, it will be the same answer. Thanks.
Well, fortunately, the next question is one where my instructions are that you were present, and that is on the 31st of August. There was a cabinet meeting, this is still 1998, where you were briefed on the arms deal. You were there, so was Ronnie Kekau, Pierre Steyn, and Chippy Sheikh. And Chippy Sheikh presented two options for the purchase of LIFT. That's the costed and the non-costed options. Now, the way that Pierre Steyn approaches this, no decision was made at the meeting, and then there was an argument afterwards about the minute that Chippy prepared and the minute that Steyn wanted prepared. Do you have any recollection of this at all, Mr. Mbeki?
You said there was a cabinet meeting.
A cabinet briefing on the 31st of August, 1998.
What I've been told about that, not a cabinet briefing.
Just hold on, maybe let me help Mr. Hoffman. It was not a cabinet meeting.
It was a cabinet briefing. Yeah.
It was not a cabinet briefing. It was Inter Ministerial briefing, as I recall it. And that is why there were only 4 or 5 ministers at that meeting. It was not a full cabinet.
No, this is what I was asking. I was saying there was no cabinet meeting.
There was a briefing.
There was no briefing of cabinet because there was no cabinet meeting. There was a briefing of the Ministerial Committee, not cabinet. Unless you got, it seems that you have got different information that there was a cabinet meeting, which was briefed.
The information is that there was a briefing at which the ministers and Pierre Steyn were present, and then there was a fight afterwards about the meeting, what the minute of the meeting should be saying. Do you have any recollection of that particular dispute in August 31st and days after that?
I don't know of any dispute about anything that would have related to, as discussed among themselves, hearing of the Ministerial Committee. I really don't know.
That's a fair answer, and let's move on to November. Because on the 18th of November...
Chair, with regards to that meeting of the 31st of August 1998, there's been comprehensive rules.
I agree with you, Mr. Castros. End up, in fact, because Mr. Stein was saying one thing about those minutes. Stein was saying the ministers probably they signed those minutes without reading them, and Mr. Castros came and explained to us that those are the minutes, and they signed those minutes. Mr. Hoffman is at a disadvantage. I'm sure he's not aware of that evidence.
I'm not aware of that evidence, and I don't think anyway, because I want to know what this witness has to say about that meeting, and he's told us he doesn't recall it, and that's a fair enough answer, and trying to do my job, that's all. All right, let's move on then to a big day, which is the 18th of November, 1998, when you announced that Cabinet had approved a 30 billion rand arms deal, given the authorization to negotiate and finalize the deals with those four had been negotiated. I hope you remember that one. And
it was a cabinet meeting.
And is it Mr. Mbeki, that in that announcement said that the deal, or the four deals really, but we called it the arms deal for short, that the deal will produce offset benefits worth 104 billion rand and create 65,000 jobs for South Africans?
Very well have been said.
Do you also, in the month of November, the then Deputy Auditor General, a man called Sharkit Farki, identified the arms deal as a high-risk deal from an audit point of view, and that he had right to investigate that as Auditor General?
No, I don't recall that. I do recall if I can remember.
Now you go to Stockholm at the end of November, 25th of November, and the Swedish complaining about being Swedish people, they were complaining about the amount of money that had been allocated to the acquisition of arms at a time when we as a nation were striving for human dignity, the achievement of equality, and the enjoyment of the freedom that we had just won. Do you remember?
I don't know. I can't speak for the Swedish people. I'm interested that you are able to speak for the Swedish people as to what they thought and said and so on. I don't know. I was in Sweden, as you say, and did whatever happens during this kind of visit. And certainly, when I came back, I didn't have some feeling that the Swedish people were of this position. But you may very well know better about this than I do.
I'm going to remind you, Mr. Mbeki, and this is inside quotes, so it's actually something that you said while you were in Stockholm. The idea that money that you are using to acquire defense equipment is necessarily money that is being diverted from housing, is emotionally appealing, but wrong. Unquote. Is that what you said at the time?
It's possible.
Are you, as you sit there here today, at a stage when, according to the National Development Plan, we have 2.1 million area for housing, 300 billion rand to build, and millions of people in shacks? Are you able to explain your reasoning when you said that in Stockholm way back then in November 1998?
We've dealt with this question, Chairperson, I thought. I said right at the beginning that the government had to deal with a whole variety of challenges, whether it's housing or water or whatever, including this one of defense. We did within the context of the Reconstruction and Development Program, and that's what happened.
Is that all you want to say about that?
That's all I need to say.
Can you explain to the Commission why it was necessary to engage in the most expensive procurement in the history of South Africa on armaments at a time when we were the flavor of the month, the new enemyless, and sitting with the leftovers of the most powerful, oppressive army in Africa? Why did we need to spend so much money on arms?
This question, Chairperson, I'm quite sure has been posed and answered in front of this commission. The rationale for the acquisition and all of that, that's been done. Certainly, as it's been done by my colleagues in the IMC and by the senior officials from defense and elsewhere in government, those are the positions that, they were government positions, those are positions that I would support. I have nothing to add to what has been presented to the Commission.
Am I understanding you correctly that you continue to toe the official party line, that you don't want to seek to justify it other than that it was a jolly good idea to put South Africa in debt to the tune of lots of money in order to acquire arms to fight enemies we don't have with money we had to borrow?
Mr. Hoffman, you have made so many propositions. Can you make those propositions one by one so that the witness can understand them and respond to them?
Who were our enemies when you concluded the arms deal?
Chairperson, there was never an official party line about this. I don't know what the gentleman is referring to when he talks about an official party line. It was a government decision which was based on very extensive consultation with the South African population, which included Parliament, and the decision was taken, which certainly to us was a national decision. Doesn't mean there were not some people who are objecting, but I'm saying overwhelmingly, this was a national view, and was a unanimous view of our Parliament, elected representatives. So, and that was also the view of government. We acted on that basis and implemented that. There was no party line about it, but then so that it became not only a government decision to do that acquisition, but a national decision to re-equip the National Defence Force.
Mr. Mbeki, my question was, who were our enemies when you spent all this money on arms?
Chairperson, we don't want to reopen all the discussion that we'll find, for instance, in the defense review. If the gentleman wants us to do this, of course, we can go and fetch defense review and read exactly the argument position. I don't know if you want us to do that, but I'm saying that this matter has been canvassed before, and indeed that would include incorporating whatever would have said in a document like the defense review, and that I have nothing to add to this.
Can you name 3 countries that were enemies of ours when you did this deal?
Mr. Hoffman, let's get to the next question. We've asked that question. Mr. Mbeki says that the justifications are contained in the defense review. If you want him to do that, he can go back and get the defense review and give you those reasons why they made the acquisition. Now, to say to him, name 3 countries which are enemies to South Africa, I'm sure it was not going to be helpful to this commission. Let's get to the next question.
As the Commission pleases. Mr. Mbeki, the next aspect that we need to move on to, because now the deals are done, and the fallout begins. And before I move...
I'm sorry, Mr. Hoffman, can you just repeat? I missed your first few words.
I say we can move on because now the deals are done, and we're getting to the next chapter of this unnecessarily long cross-examination. So, before I do that, is it correct that Trevor Manuel was initially not in favor of the arms deal and had to be persuaded to support it?
No, he never told me that. And I don't know whether he was asked that question when he appeared before the commission, because he would have been able to answer the question. But he never told me that.
All right. No, that was just an aside. It's also true that South Africa had to borrow money in order to pay for these arms. Is that not so?
Sure. Yeah, it is so. Yeah.
Sorry, and the Public Finance Management Act is what it's all about. That's what tells you how you go about borrowing money for public purposes.
Chair, as my learned colleague will know, the Public Finance Act was not in operation then. It only came into operation in 1999. It was the Exchequer Act which was applicable at the time. And in any event, these very issues have been extensively covered by Minister Manuel.
Commissioner, I'm responding to some of the evidence in chief. The wording of the relevant wording is identical in both acts, as my learned friend Mr. Marani knows. And the point that I'm wanting to make with the witness is simply this, that the Minister of Finance is indeed entitled to borrow money, but under Section 71F, the kind of borrowing that was done, and it was big borrowing, to finance the arms deals, is the kind of borrowing which is called borrowing for any other purpose approved by the National Assembly by special resolution. That's what the law says.
I'm sorry, Mr. Hoffman. That section...
It's Section 71F of the Public Finance Management Act.
But then I think the evidence that we have and what Mr. Morales says, at the time of when these deals were made, the Exchequer Act was in operation and not the PMFA Act. And I think one of the witnesses dealt with that issue in detail.
He has dealt with it, and that's why I'm challenging him. My instructions are that the wording in relation to this issue is the same in the old Act as the new, so I'm referring to the new because it's just easier to find. And the point that really the question is, are you aware and can you point the Commission to any special resolution of the National Assembly that gave Trevor Manuel the permission to borrow all that money that he borrowed in order to, and if there is one, I'll be very happy to know that there is one. I don't know of one, and it worries me that this borrowing was done en passant. I'm not putting it to you that there wasn't a special resolution. I'm putting it that a special resolution is required, and I have not, in all of the paper that I've read in this, ever seen such a special resolution.
This issue of the borrowing, question of the loans, from the subject matter of an action which was brought by the learned colleague's client in the Cape High Court, where he lost. He applied for leave to appeal to the SCA, he lost. He went to the Constitutional Court, he lost. So that issue in our submission is res judicata. A court of law has pronounced on the validity of those loans, etc. I don't see why we should be revisiting that, rehashing that.
I was unfortunately not in that earlier litigation because I was still a proper lawyer then. I was still a proper lawyer in the old days, not an NGO worker. So I was not in that earlier litigation, but I've read the judgment, and as I understand it, the finding of the court is that the applicant, which was Exchequer, Mr. Crawford Brown, sued the wrong party. There's no res judicata on this point, and this point is an important point for this commission, because if it happens that a special resolution of Parliament was required before Mr. Manuel took his loan, then this commission is in honour bound, I would suggest, to find out about that. And that's all I'm trying to do. I'm not trying to be clever. I'm not trying to suggest that there wasn't one. I'm asking a question that I don't know the answer to, which is always dangerous cross-examination. But this is important enough to do.
You know, I remember when I was still young, I was told that when you cross-examine, if you don't know the answer, then put the question to the witness. Now, this is exactly what they do. Mr. Mbeki, are you in a position to tell us whether, are you aware of any resolution of that nature or not?
Chairperson, at no point did the government act in any illegal manner, knowingly or unknowingly, as far as we're concerned. And this matter that is being raised about what might be said in the then legislation as it existed, as I was saying earlier, I'm sure that the matter could have been put to the then Minister of Finance, because indeed, as it says, the Minister of Finance borrowed. It could have been put there, and I'm quite sure that you would have dealt with, if it's not already been dealt with in the courts, as Advocate Morane says.
Thank you, Advocate Hoffman. In any event, I think you can still raise this question during argument.
We'll do it as a matter of discovery from the Commission. It's a government document that either exists or doesn't, and we can do it via documents. If there was a quick answer and the witness knew, we would have saved a lot of people a lot of time and trouble looking for a document which may or may not exist. Okay. I was trying to be helpful, even though I do it in the worst possible way.
Okay.
To be helpful, Chair, I think reference can be had to Section 16 of the Exchequer Act, which says the Minister of Finance may at any time borrow monies, aid, to finance anticipated deficits in the Exchequer account, obtain foreign currency, etc., etc.
Is that helpful to you, Mr. Hoffman?
Yes, I understand it's the same as the PFMA. My client's a banker, fortunately, so he knows more about these things than I do. But the difficulty is that this is a question of a foreign loan. It's not just borrowing money locally. And I don't think we need to debate it now. I don't think it's fair to Mr. Mbeki for us to sit here and be clever lawyers while he's trying to actually give evidence.
Mr. Hoffman, how long do you think you'll still be busy with the witness? Because I think I'm going to sit until we finish this witness today.
Well, I am now in...
Just more or less, how long do you think?
I'm in my chronology, I'm in the happy year of 1999, which was a very happy year because Mr. Mbeki won presidential election by a landslide. And I need to take him at least to the end of his presidency, which is 2007. I don't think there's as much detail, but I have a plan. I'm still on chapter 1 of the plan, which is to try and help the Commission by giving you a chronological sequence.
Mr. Hoffman, that I understand. The simple question is, are you still going to be busy for an hour, 2 hours, 3 hours, 4 hours, so that we can know how to plan our things? That is the only question that I was asking.
It depends on how often Mr. Marani interrupts me.
Okay. I think in that case, let's adjourn for 15 minutes. We'll come back, and my fellow commissioner said to me that we are going to sit until we are done with Mr. Mbeki.
Mr. Commissioner, I'm going to request on behalf of Lawyers of Human Rights to, after this cross-examination is finalized, to get the opportunity to consult with my clients. You will appreciate that the statement that we received this morning of some 11 paragraphs and 4 pages.
I understand that. You don't have to motivate it. When I said we need to finish, I was referring to Mr. Hoffman.
Oh, okay.
To Mr. Hoffman. If we finish with Mr. Hoffman today, then we can come back to you tomorrow.
Thank you, Mr. Chair.
Advocate Moerani, tomorrow unfortunately will have to be to come back. But then, so that we can finish timelessly tomorrow, I think we're going to take a 15 minutes adjournment, and from there continue until we finish with the cross-examination of Mr. Hoffman.
Chairperson, maybe we can discuss this later because I'm not available tomorrow. And my learned junior is not available tomorrow. I've not discussed President Mbeki's a diary for tomorrow. Maybe we can come back to this issue. We would be prepared to sit as late as possible today.
Yeah, I understand that, but then we have a problem from Lawyers for Human Rights. They say that they might need to prepare for their cross-examination. And if that is the position, unfortunately, we'll have to say that Mr. Mbeki will have to come back tomorrow morning. Because we want to do is evidence and cross-examination and finish so that we can get into the next stage. I think we'll discuss that when we will discuss that further when we come back from tea. Let's take an adjournment of 15 minutes and then we can take this issue further. Thank you.